Can you hear me?
Good morning, everybody. This is Judge Nicola.
Morning, Your Honor.
Good morning, Your Honor.
Good morning.
Morning.
We're on record in Asset Acceptance LLC versus Brenda Mora, which is case number 2009 CC 302. This is Ms. Mora's claim of exemption.
Yes, Your Honor. My father.
One quick second. So, Ms. Mora, I received from the plaintiff an affidavit in opposition to the claim of exemption because they are indicating that they've requested that you fill out the fact information sheet that was never filed by you, and they're saying they don't have any information on your claim of exemption to allow them to defend your affidavit. So I guess my question to you is, are you able to provide to the plaintiff information to support your claim that you're supporting your dad? Is it your dad or your father-in-law?
My dad, my father.
To show that you would have a valid claim of exemption, because it seems to me like that information needs to be provided to the plaintiff first before I can address your claim of exemption.
Yes, I believe I filled out everything I received, but if they send me whatever they send me, I can fill it out. Yes.
Ms. Angioni?
Yes, ma'am. So the fact information sheet was sent right after the judgment had been sent over. And again, we sent it with the exemption forms and we have not received it back. So we don't have that information to go through, which again, as you properly stated, that's why we're here.
Right. All right. So, ma'am, I think that in order to proceed with your claim of exemption, we do need to have you fill out that fact information sheet and send copies of all of the relevant information to the attorney for the plaintiff, which include information to support that you are in fact caring for your dad full time due to the health issues and or COVID-19 that was outlined in your affidavit. And then what will happen is the court will reset your claim of exemption, and then we'll need to take testimony from you, sworn testimony. That's how we proceed with these claims of exemption. But I think it puts you at an unfair advantage to not have you at least fill that information sheet out. And let me see here. Yeah, let me see when that information sheet was filed. Is there any way, Ms. Angioni, that you could actually provide that again to Ms. Mora in order to just facilitate moving this forward? And Ms. Mora, could you make sure that you have a good address to provide to Ms. Angioni so that if we come here again and I find that you have not filled out the fact information sheet and or provided information that is requested of you in order to support your claim, I won't have any choice but to deny it. And I understand, because you're pro se, that a lot of times litigants just don't understand that providing that information has to be done in advance of the hearing. And that's why I'm giving you the opportunity to do that before we move forward. Does that make sense to everybody?
Yes, Your Honor.
Yes. May I have an email and a valid address, Your Honor, so that I can make sure that I send this to the right information?
Okay, Ms. Mora, could you provide that, please, to Ms. Angioni? Am I saying your name correctly? Is it Angioni?
Yes, ma'am.
Okay, thank you.
Okay, so B as in Brenda, AM 3691 at AOL.com.
Okay, and your physical address, please?
Right now, I am with a P.O. box. Can I give you a P.O. box?
You can, but you have to understand I'm going to mail something to that, so you need to make sure you're picking it up. So you get it. Okay.
Yes.
Okay, thank you.
So it will be P.O. Box 110752, Naples, Florida 34108.
Okay, thank you very much. And do you have a telephone number that you want to give us so that we can speak after we review everything?
Sure. It's 239
Okay.
248
Okay.
3717.
Okay, wonderful. Thank you.
Okay, so you will be sending me all the information.
Well, I'll be sending you what's called the fact information sheet, which was what the judge referred to, and what it asks you to fill out a series of questions.
Okay.
Thank you.
Thank you.
All right, so what we're going to do at this time is we are going to reschedule this matter to February the 4th at 9 a.m. Because I'm not seeing that I have a motion docket in January for whatever reason. So it makes sense to me to schedule this for my February 4th date. That gives you about a month, a little over a month, to get the information to the plaintiff and then, excuse me, we can set it for the February the 4th date, and hopefully everybody will have all the information they need, and we can go forward with the claim of exemption then. I just don't want to leave this dangling and then, you know, get set many months ahead. I'm expecting that we'll still be doing these by Zoom in February, so I'll just send you guys a new Zoom code, and then we will, and then we'll schedule it then. Let me just make sure this person that's waiting is not waiting for this hearing. Just got somebody named Ollie Rahavenard. Good morning, Mr. Is it Ronavard?
Yes, Your Honor.
What hearing are you here for this morning, sir?
Velocity versus Jonathan Dalton.
Velocity versus Dalton. I think that's being heard later.
I think so, Your Honor, because I reviewed your docket for my case and I remember seeing that one.
I think that one is going at 10 a.m. it says.
Okay. I'll return at 10 a.m., Your Honor.
Yes, sir. Okay, we'll see you then. It'll be the same Zoom code. Just come back. Okay. All right. Okay, so everybody, we're good. We're set now for February the 4th at 9 a.m. Everybody knows what they need to do to get us ready for that. And we'll see you all then, okay?
All right.
Thank you, Your
Honor.
Thank you. All right, bye.
Bye.
All right, and Maria, I'll see you at 10. I think that's the next one, right?
That's the next one, yep.
Yep, I'm just putting the meeting on.
Okay.
Hi, good morning again.
Good morning.
Okay, let's see. This is the one that's supposed to be heard at. Oh no, we took care of that one. Good morning. That one was taken care of. And we have Mr. Dalton, good morning.
Good morning.
And we had the plaintiff's attorney in earlier. He zoomed in early, so I told him to come back in at 10.
Okay.
So he should be here in a minute, I hope.
Okay.
I did tell him 10, didn't I, Maria, when he came on, I hope? Been kind
Yes,
of-
you did. You told him 10
Okay.
o'clock.
All right, good. Oh, there he is.
Good morning, Your Honor.
Morning, Mr. Ronavard. Okay, and we have our defendant, Mr. Dalton, who's also present via Zoom. And I have reviewed both the claim of exemption and the affidavit in opposition to the claim of exemption. Is it the position of the plaintiff that the plaintiff doesn't have has insufficient information from the defendant to proceed with this hearing, or are you seeking to proceed with this hearing and you're simply objecting to the claim of exemption? What posture are we in this morning?
We're objecting to the claim of exemption, Your Honor, and would like the opportunity to question the defendant.
Okay, so you're okay with us proceeding with the hearing, you're just simply objecting to the
Yeah.
claim of
Yes.
Okay. All right, so Mr. Dalton, because you have filed an affidavit indicating that you should be exempt from the writ of garnishment, what we need to do is we need to take some testimony from you this morning as to why you believe that you should be exempt from garnishment. So what I need to do is have you sworn in first and foremost.
Okay.
Raise your right hand and be sworn. Do you swear and affirm that the testimony that you will give this morning will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. All right, so Mr. Ronavard, you may inquire, sir.
Yes. Sir, are you still employed with Tenant Healthcare?
I am.
Okay, and what is it you do at Tenant Healthcare?
I'm a pharmacist.
And are you paid on a weekly, bi-weekly, or monthly basis?
It's a bi-weekly basis.
Okay, on a bi-weekly basis, what is your take-home prior to the garnishment?
It's approximately $3,000 every 2 weeks.
All right, and your claim of exemption form indicates you're claiming head of household, which means you're providing more than one half the support for a child or other dependent. Sir, can you please
Correct.
tell us who you're claiming as your dependent that lives with you?
I have 4 sons that live with me, 17, 16, 14, and 13 years old.
Is there anyone else who lives in the home with you?
No, just myself and my 4 boys.
All right, and your 4 boys, do their mother or mothers provide any form of support?
They see their mother every weekend on Saturday and Sunday, but the divorce settlement was I pay for everything, all their needs and everything. Clothes, books, medicine, healthcare, everything.
Okay. And do you rent or own a home, sir?
I rent
What is your rent per month?
$2,100 per month.
I have no further questions, Your Honor.
Okay. All right, Mr. Dalton, is there anything else that you would like to tell the court in support of your request for a claim of exemption?
No, other than I do have a divorce settlement that I pay $2,500 every month to my ex. Even though I do have the children, I pay her $2,500 every month. That's why this would be a huge financial burden if there was any more taken out, since I'm pretty much in the negative almost every 2 weeks.
Is the $2,500 spousal support?
It is.
And when did you enter the agreement for the spousal support? Was it within the last 2 years?
Yes.
Did you enter an agreement for the alimony to be taxable or non-taxable?
I found out last year it is non-taxable, so I cannot claim it at all.
Okay. I asked you that because I used to be a divorce attorney and I'm very familiar with the change in the alimony law. It happened
Well,
right-
I just could not believe it. I have to claim it as income and she does not. So anyway, that's not here or there, but
Well, it makes a difference with how much comes out of your pocket, because in fact, if it were taxable, you would receive the tax benefit at the end of the year for paying that amount of money.
correct.
But with the alimony law, it's no longer taxable, and as a result, you're paying $2,500 out of your pocket every month. So,
Correct.
and how long does that alimony last? Is it permanent, periodic? Temporary?
Until my youngest turns 18 and he's 13.
13. All right. Mr. Ronavard, any other questions for this gentleman?
No, Your Honor, and plaintiff's position would be that he certainly seems to qualify, so we're not going to hold further objection.
It seems to me like he qualifies as well for the exemption. So what the court will do at this time is the court is going to grant the exemption, Mr. Dalton, which means that the garnishment will not continue. But what I can tell you is it sounds like when your youngest child turns 18 or reaches the age of majority under the divorce laws, that the plaintiff may have a pretty good claim for the exemption. So it may not be a bad idea for you two gentlemen to talk at some point, maybe to start figuring out a way to come to some agreement so that some payments can start once your children are all grown and out of the house. That way you don't end up back in court on this. I mean, there's usually some type of a resolution that can be had if everybody kind of talks to each other, but it sounds like you got a full plate at least for the next 5 years or longer than that. Then you're gonna have kids in college too, probably, which kind of complicates things as well. But you know, there might be some resolution on this. The total amount that's due on this is how much, Mr. Ramadan?
As of today, I show a total of $1,646.04.
Yeah, so $1,600, you know, that kind of compounds with interest over the next 5 years might be a lot of money. Whereas if you could, you know, figure out some way to make some like $50 payments or something, you might be able to knock this thing out in a few years and have it off your plate before your kids are of majority. But that's just the court's thoughts for today. Sometimes, you know, $10,000, $15,000 is overwhelming, but $1,600 when you break it down into small little payments, you're at least making something, you know, might be some way of getting it taken care of. But I'll leave it to you two gentlemen to talk about that. Maybe that's for another day, but just the court's thoughts on a Monday morning. So thank you both. Mr. Am I saying your name right? Is it Ronavard?
Yes, you are, Your Honor. That's correct.
Could you send me in an order granting the claim of exemption, please, when you have a chance?
Yes, Your Honor. I'll get that done ASAP.
And it'll get copied to you too, Mr. Dalton, and good luck to everybody today.
Thank you.
Thank you.
Thank you both. All right, that concludes our 10 o'clock docket, and we're going to go off the record until 10:30.
Okay, see you then, Your Honor.
All right, let's see if we got everybody. Good morning, everybody. Sorry for the delay this morning. Just a wee bit behind. Okay. And good morning. This is the case of Midland Funding versus Jesus Ramos, 2007 SC 1032, claim of exemption hearing. Mr. Ramos looks like he's connecting. There he is. Mr. Ramos, can you hear the court?
Yes, ma'am.
Okay, great. Wonderful. Okay, so we are here this morning on the claim of exemption that was filed by Mr. Ramos. Looks like it was filed November the 16th. And sir, when I look at your claim of exemption, it doesn't contain any checked boxes or anything that allows either the court or the plaintiff to understand why you filed the claim of exemption, sir.
Well, I was filing the claim of the guardian exemption because I had this account probably over, I'm gonna say 15 years ago. And to my understanding, I actually paid that directly to expired, and it was only like $400 and something. And then I received, well, actually, I did not receive any notification of anything. I was surprised when I saw my salary garnished. So I went to the courthouse and find out that they send it to the wrong address or whatever it is. And they had a judgment, and like I said, I'm not sure about the correct words. However, I was under the assumption that was already paid in full, and this is over 15 years ago. And then the judgment was back in 2009, but I thought it was already taken care of. So that's why I did not move. I'm not denying of paying anything, be honest with you. They already took the money. But I was just very curious why it took them so long to let me know and make this go so far. I mean, I paid almost $2,000 just now I just finished taking the last $52 out of my paycheck, and it was really devastating for my financials, you know. But I just want to know, that's what I had the hearing for, to see if they actually did act according to the law. Other than that, I'm not denying any debt. I worked so hard to get my credit where it is right now, but I just want to know if this was correct. If it's correct and you guys said that it's correct, I just want a paid in full letter saying that I don't owe anybody, and we just call it, because I'm not going to make you waste your time, Your Honor. And, you know, that's all. I just want to know if they act according to the law. This has been over 15 years, that debt that it was already taken. I don't have any proof. Be honest, back then, I don't have any. So whatever you guys said, whatever they said, I guess I have to take the word for it. But I just want to know if they are according to the law. That's it.
All right, so sir, I'm looking at your case 071032SC. It appears that the complaint against you was filed back in 2007, in April of 2007, that there have been lots and lots of court proceedings since the final judgment was entered, and the final judgment was signed September 25th, 2009, well before I became a judge. And it looks like in 2013, there was a motion for a continuing writ of garnishment, which was actually signed March 15th of 2013. And then after that, there was a claim of exemption, which was filed in April 24th of 2013, and an objection in 2013. There was a request for an order of final judgment of garnishment, which was filed May 6th of 2013. And then there was a final judgment of garnishment, which was signed by the court June 6th of 2013, ordering that the garnishment be had. Since that time, it looks like there have been several substitutions of counsel, at least one that I can see, I'm sorry. And in October of 2019, oh, wait a minute, I'm sorry. In June of 2013, there was a claim of exemption that was filed by you, sir, which was granted, and the court granted your claim of exemption and dissolved the writ of garnishment. So what happened then was October of 2020, about 4 years later, 3.5 years later, there was another continuing writ of garnishment that was filed that this court did sign. And the return of service came in November, and then Fifth Third Bank filed an answer to the writ of garnishment, and then you filed your claim of exemption. Now, your claim of exemption, which was filed, should have told the court that you were exempt because you were the head of household, or you paid over 50% of the money for a dependent spouse, child, or elderly person, and that you had a valid claim of exemption. You filed the form, but the form that you filed doesn't properly claim an exemption. In order to properly claim an exemption, you would have had to have filled out that form. There really isn't a form to say to the court, Judge, I need to know how much money I've paid thus far and whether I owe any money. The plaintiff does have an obligation to provide to you information which shows how much money you've paid and how much is left, if you want that information. My guess is, from looking at the file, that back in 2016, there was an order of garnishment that was granted, but then it was dissolved almost immediately. So I can't see from your file how much money was actually paid pursuant to that garnishment. But if I were to guess, it wouldn't appear to be a lot. And so I cannot grant the exemption, but what I can say to you is that I think it would be prudent for the two of you gentlemen to talk, to figure out how much money is owed by you, Mr. Ramos, and you know what's left, and see if you guys can come up with a resolution of how to just get it paid. Mr. Garrett, do you have any idea how much money is left to be paid by Mr. Ramos?
Good morning, Your Honor. Anthony Garrett, plaintiff. We show that there was a $2,400 and change judgment in 2009. It looks like it's down to about $2,000 now. It looks like maybe some money came from Verizon a few years ago, but it looks like he still owes about $2,000 according to our records.
Okay, yeah, we definitely need to figure that out. So, and how much money is being taken out of his paycheck for this garnishment? Do you know?
I mean, it looked like it may almost be paid. It looks like it was about $500 a paycheck, and he probably knows better how much has been held back so far.
I can tell you exactly. The first time they took $510, then they took $810, and then they took $520, and then the last paycheck, which is last Friday, last Thursday, they took the last 52. So that should take care of it, the whole thing already.
I think what he's suggesting is that his employer has held whatever the continuing writ of the maximum amount requested in the writ. So he may be paid in full, but the money's being held by the bank still, by his employer.
Okay. So could we do this? Could we stay the writ of garnishment pending an accounting of what's owed and have an order directing the bank, the third, to release the money to the plaintiff so that we can get a proper accounting? If he's paid, he's paid. If he isn't, it sounds like there might be a little bit left over. We don't want to continue to garnish this gentleman's paycheck. It sounds like it's been paid, but I think I could enter an order staying the garnishment. And if it hasn't been paid, then we just enter an order setting aside the stay. Would that make sense, at least till we can figure out how much is paid and what's left?
Certainly, because it looks like based on when they started paying, I think probably close to the full amount has been garnished.
Mr. Ramos, does that work for you? What the court is saying is that I'm going to stop the garnishment temporarily, so they'll stop taking money out of your check. We will order Fifth Third Bank to release the money to the plaintiff that's being held pursuant to the writ of garnishment. And then if you've overpaid, you get wherever you've overpaid back. And if you've underpaid, then we figure out a way to get that paid. That way it looks like everything's done.
Yeah, and that's fine. I already contacted my legal department from Fifth Third as well, and they told me that the last amount was 50 something was taken care of. And I even called the office of the lawyers, and what they told me that they couldn't even help me because I tried to go ahead and resolve this in a different manner, and they told me that the only way that they could resolve this is by going to the judge, to you. So, and they told me that it was like close to $2,000 total owed, and that's what they garnished for. So if it's that what it takes, like I said, I feel like I pay way too much this in here. I just don't want my salary to be garnished anymore.
Okay. Well, we're going to stop the garnishment for now, and that'll allow you two gentlemen to figure out exactly what the balance is, if any, because it sounds like there was some money paid from Verizon and maybe from somewhere else, and then through your employer right now at the bank. But it sounds like if you're not done, you're close to done. And if you owe like $50 to them, you write them a check and we terminate this, right?
Yeah,
or if they owe you $50, which either way, we figure this out. So, but I'm going to stay the garnishment for now and enter an order releasing the funds to Fifth Third. That way, everybody has an idea of what we got. And then, Mr. Garrett, if you could look at your records too to figure out how much money your records show to Midland Funding. And between the two of you, Mr. Ramos, if you have information to show that you paid more than what Mr. Garrett has, then we can figure that out too. But it sounds like we're close. So I'll leave it to you two to get together on this issue. Do you each have each other's contact information so you can provide information to each other either by email or phone or mail or whatever?
I can call the office like I called that time, and I guess once you granted the release of the funds from my company and they get the money, I guess they will figure it out of the total amount, because that should be according for what they told me in their office. That was the last amount that I supposed to pay. That was the last $50 something that they took out. So I would assume that would be completely finish this debt, and all what I need is just basically a paid in full letter of give me 1 second, of that it's already being taken care of. Right.
Okay, I just need you to work with Mr. Garrett to make sure that we've got everything paid. But maybe me signing an order to get the bank to pay the money will expedite things, and that way we'll figure it out from there. And if everything's good, you guys just let my office know, and then this matter will terminate. We'll terminate the writ of garnishment. Basically, right now it's just being stayed, which means I'm stopping it, but I'm not terminating it in case there's more money that's owed. Okay. And then we can go from there.
And Mr. Ramos, my name won't help you because I'm just covering for them today. So go back to, do you need a note? You have a number for them?
Right now I don't have the paperwork with me, but I do have a paperwork for the your office.
All right, it's for Midland, because they
Yeah.
use different offices, and this time they've got a Michigan. Even though they're in Tampa, there's a Michigan address on the last paperwork they filed, a phone number, an 800 number.
Okay, I just called them and I talked to the accounting lady. She said that she looked the case over, and then I guess she'll give me the information.
Great.
If there's anything else that the court needs to do in order to assist you guys in this matter, please let me know. But it sounds like you're all on the right track to getting this concluded.
Thanks.
All right.
Thanks a lot.
Your
All
Honor.
right, thank you, everybody. Have a
Thank you.
wonderful day. Thank you.
Thank you.
And
Bye-bye.
we're off the record until 11 o'clock.
Yes, Your Honor.
Thank you.
Thank you.
Waiting for our participants.
Okay.
They didn't cancel and just not tell me, which happens occasionally.
That would never happen.
Happened more frequently than not lately.
Yeah. It sure has.
I don't mind if they cancel. I just mind a little bit when they don't tell me. Oh, wait, there's somebody. Good morning, Mr. Sawicki.
Good morning.
Good morning. We're still waiting for Mr. Carrera. We've had a little bit of trouble with Zoom this morning.
Okay.
We'll give them a little bit of an opportunity to either Zoom in, or lots of people still think they're supposed to come here even though they're not. So.
And this is my first time using Zoom. It worked flawlessly.
Yeah, it's becoming a wave of the future, at least in the near future. So that's what we got. It works okay. It's better than nothing, right?
Right.
So. And Maria, this is case number 20 CC 1722. Let me just make sure that my assistant was able to get a Zoom code over to the defendant. Hey there, were you able to get a Zoom code over to the defendant, Mr. Carrera? You've never heard back from him. Okay. All right. So we'll just wait a few minutes, and if he doesn't show up or he doesn't call in, we'll just proceed in his absence. Thanks. Bye. Take a quick look at the notice of hearing that was sent on November 17th. Not look like it came back. You guys find out if we have a line at the front door just to make sure. Otherwise, I'm going to start with the hearing because it's a little after 11. Unless there's a line, we will proceed. Three people? All right, we'll give them a couple minutes. Mr. Sawicki, are you here as power of attorney for the plaintiff, or are you here representing her, or both? I was kind of unclear. I saw this emergency pro se motion to add power of attorney.
Strictly power of attorney.
Okay.
But she's somewhat incapacitated up in Indiana.
Oh, okay.
Physically, not mentally.
Oh, okay. And probably doesn't have the capability of zooming into our hearing today.
No. No.
Although I do allow people to appear by phone if they can't figure out the Zoom thing. And also Zoom does accommodate people calling into it, but the instructions appear a little complicated. So a lot of times people don't understand it, that you don't actually have to have the technology, the computer and, the ability to video in order to use Zoom. You can actually call in over the phone. But I think the instructions are, sometimes people don't understand them.
Right.
So, yeah. But he's not here. So I'm going to move forward with this hearing. I did see his answer that was filed, and it just indicated to me that he had paid the month of November of $895, and there was a deposit in the amount of $895, which I'm thinking he's requesting be the last month's rent, even though we're like a few days away from the end of the month. Do we know whether he has moved out?
No, I believe he's incarcerated.
Oh, that might be why he's not here. We can find that out.
I have a case number if you want to.
Yeah, I'm loading cases on him right now. Hopefully it'll pop up.
Does that make a difference?
I'm not sure, to tell you the truth. Let me look at what we've got here. Boy. Is it 2020 MM 2033?
Yep.
December 15th. Let me just see what's going on with his case. Let's see, first appearance order. Let's see what that says.
And it looks like he had some kind of a hearing supposedly for today, and then that was changed to January 4th.
It probably was. See, there was a first appearance order December 16th. My guess is today probably would have been an arraignment. Continue to 1-4. Let's see, application for indigency. If I were to think this through and think probably what happened is that this defendant was found to be indigent, which means he was appointed the services of the public defender and he appeared for an arraignment. Well, it says he didn't appear, but the public defender was probably there with the judge this morning, and it probably would have gotten moved to a pre-trial conference. And that pre-trial conference was set for January the 4th. Look at this again.
Right. It looks like it got thrown over to you too as the judge.
I was about to say, is this going to be my case? And it is, of course.
From what I'm reading.
Okay, which doesn't matter here or there that it's going to be assigned to me. However, I would like to be able to have him present. And so what I'm going to do with today's hearing is I'm going to reschedule today's hearing to tomorrow at 2:15. I'm covering first appearances for Judge Provost tomorrow. So what I'm going to ask the jail to do is to have him present in order to have this hearing proceed. He'll be over the monitor in the jail unless he's in. We got to try and figure out this guy, John Carrera. He's in jail. He's in custody. So I'm going to continue the civil hearing. It's an eviction to tomorrow and see if they can just bring him out with the other people they're bringing out for 24. So I can let him know he's being evicted. I feel weird like not having him here knowing that he's in jail. I just want to make sure we can do that. I think that'll be a problem if he's in there. Okay. Okay. Well, I'm covering for Judge Provost tomorrow, so I'm doing 24s tomorrow. So what I was thinking is I would have Mr. Carrera brought over. On this case, we reset this to tomorrow so that we can have him over Polycom in the jail, and I can say to him, you're incarcerated, but I don't see any defenses to the eviction, because I really don't, other than the fact that, the rent may be done on the 31st, and at least allow the gentleman the opportunity to have somebody go to the unit that he's renting from the plaintiff and get his stuff out, because I'd hate to have somebody be in jail and have all their stuff removed and then put on the street or whatever. There's a kindler, gentler way to do this so that he understands we don't, we want to be able to give him an opportunity to get his stuff out. Because it sounds like he's in jail. He may or may not be getting out, but the eviction looks like it's proper. But I still feel like I need to have an opportunity to have him present. So that kind of solves a lot of problems. If I can get the jail, I bring him over tomorrow at 2:15, and I'll bring you guys back in over Zoom. What I'll do for you, Mr. Sawicki, is I will give you the Zoom codes for tomorrow that I usually use for my criminal docket, and we'll have your case basically heard to it whenever it can accommodate the jail. If he's going to be brought in with the other inmates, I'll do it at the end of my 2 o'clock docket. If they want me to do it later, I'll do it later. We just, there's a lot of moving parts when you're dealing with people over in jail, and they're not bringing them over right now. So, but I do want to, in light of the fact that it looks like this eviction is proper and there's been no COVID defenses, I want to be able to hear from him, at least some resolution for him getting his stuff out if he hasn't already.
Okay,
If he even wants to, I don't know.
We're just plain and simple not renewing his lease, and that was, notice was given back in October.
Right, I saw that, and I do understand that, but I want to make sure that he understands that. And I have a way to do that, especially in light of the fact that I'm going to be the judge for tomorrow's cases that are dealing with the jail inmates. So it's kind of a win-win for everybody that I signed on board to do those hearings tomorrow. And I'm already going to be there, and I'm already going to be addressing the inmates that were arrested the night before. So hopefully we can get everybody on board to bring him over so we can address this with him. I'm going to go back and talk to my judicial assistant and see if we can't, if there's any problems with it, we'll get in touch with you, Mr. Sawicki, and let you know. I do need, I think, to get from you your contact information. It wasn't clear to me how we get in touch with you so that we can notice you in case there's a problem for tomorrow.
Phone number is 239-595.
Okay.
7448.
Okay.
And email is the letter C as in court.
Yep.
Naples @comcast.net.
cnaples@comcast.net.
Yes.
Got it.
And is it Julie, your assistant, Mrs. McAllister?
Yes, Jen McAllister is my assistant.
Yeah. So she emailed me everything. I contacted her this morning, and she emailed me all the links and everything.
Okay, perfect.
Yeah.
I'll just have to need to get her to email you the first appearance Zoom link for tomorrow, because I change mine every day, and they're password protected because of all of the difficulties sometimes a public Zoom has. So I make sure that mine are all privatized, and I haven't had trouble so far.
Okay.
So yeah. All right. So that's going to be my order. We'll move it to tomorrow at 2:15. I'm going to check with the jail, make sure we can have him brought over with everybody else, and then we'll address him then and see if we can't come up with some resolution to getting him out of there and getting your client back in possession, and just making sure all the moving parts are satisfied. Okay.
Okay. So then after tomorrow's hearing, if everything goes according to what I think is going to happen, would I just then do my whole process of writ of possession, final? Okay.
Yes. If everything goes well tomorrow and everything's in order, then it would be the normal procedure with doing the writ of possession. I saw in the file that there's an e-filing directive that came from the clerk's office. That's to the lawyers, so I don't know anything about that, but that was generated by the clerk's office, that they're not handled in paper. I guess there's an e-filing protocol. But other than that, the final judgment of possession would be in fact signed by me.
Okay.
Okay.
Very
all right.
good.
Sounds good.
Thank you.
All right. Thank you. Maria, we're okay with doing that, with getting everything moved over to tomorrow?
It may need to have to go to 2:30 just because you have a criminal proceeding. I can't schedule that with a civil.
Okay.
So they may have to make a 2:30 docket for you.
Okay.
And it may even require switching clerks. So we'll have to be in touch with Jen to let you know.
Okay. All right. Well, we'll figure it out. Either way, if we can get it working so that the jail can bring him over, I think that's the best thing to do in this case. Okay.
All right.
All right. We'll figure it out. We'll let you know, Mr. Sawicki. Okay.
I'll wait to receive the email then.
Okay. Sounds good. Thank you, everybody. That concludes this meeting for this morning.